Sheriff, Uncle Sam says, let my veteran go. And veterans, you must insist on military due process you are entitled to. Demand it, claim it, and own it. Because if we don't do that, if we don't go demand it and claim it, they ain't going to give it to you. Right? We're going to have to be the ones that go and get it. And what the sheriff needs to understand is that we are entitled to military due process. And that's what this video is about. I'm going to show you where it says it. It makes it really simple for the sheriff. Just say, well, civilian court, unless you provided this man military due process, I have to let him go. I can't hold him. And do you understand that if every veteran who is being held was to be released because he had been denied military due process, then all them bonds that were created in those court cases would all go into default, and all them deep staters would end up paying the price for defaulting on their bonds. Right? Their business is with the devil, and the devil is going to get his pound of flesh. But it won't be coming from us because we were denied military due process. But for that to be true, we have to go and claim it. So let's talk about it a bit. I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. Email address is courtofrecord@aol.com. And my phone number is 616-712-6179. And you can find me on YouTube at Rob Ryder with 3 B's, ROBBRYDER. And, just to show you some of the things that the Supreme Court's already said in Parker versus Levy, just as military society has been a society apart from civilian society, so military law is a jurisprudence which exists separate and apart from the law which governs in our federal judicial establishment. There's the fucking establishment. Excuse my French, but I always wondered what they mean by the establishment. I guess they mean the federal judicial establishment. So, Sheriff, we veterans are not challenging your authority. We are directing it for maximum effect. And the deep state by releasing all veterans so the deep state agents default on their bonds. We can all sit back and watch. So let's get into this a bit. This won't take long. And then I'm going to offer, just some verbiage that if you're a veteran, you may want to send to your sheriff, right, about a situation you may find yourself in, to see if they do something about it. But until we inform them, we can't expect them to know this. If you're watching this video, I'm sure you don't know what I'm about to show you because we never read the UCMJ. Although we're, required to. As a veteran, you're required to know the UCMJ. It's really that simple. Okay, let's see what it says. Hang on. Okay, so any document I show in this video is easy enough to find online. That's where I got them from. Or you just need to search on the titles. Click on a few choices and see if you're looking at the same thing. But here's an example. That the Congressional Research Service, which is a bunch of attorneys that look at shit for the Congress and make, some kind of decision on it, a legal determination about it, wrote this military court-martial under Military Justice Act of 2016, which is just chock full of all sorts of good information. Unfortunately, we can't sit here and read it all, but let's just go to the parts that we're going to talk about, which is this military due process. So it says that the U.S. Constitution imposes on the government a system of restraints to provide that no unfair law is enforced and that no law is enforced unfairly. What is fundamentally fair in a given situation depends in part on the objectives of the given system of law weighed alongside the possible infringement of individual liberties that the system might impose. In the criminal law system, some basic objectives are to discover the truth in order to punish the guilty, proportionately with their crimes, acquit the innocent without unnecessary delay or expense, and prevent and deter further crime, thereby providing for public order. Military justice shares these objectives in part, but also serves to enhance discipline throughout the armed forces, serving the overall objective of providing an effective national defense. Right, the Fifth Amendment of the Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. Due process includes the right to notice an opportunity to be heard whenever the government places any of these fundamental liberties at stake. In the civilian setting, the exact process that is determined by the balancing of interest affected, individual or government, the risk of erroneous deprivation of such an interest, and the probative value of additional procedural rights. However, the Supreme Court has held that this balancing test does not apply in the context of military justice. Rather, the military justice system falls under Middendorf versus Henry. Right? So there's a Supreme Court case that's going to tell about military justice. Right? The precedent's been set, which calls for a test of whether factors favoring a particular right are so extraordinarily weighty as to overcome the balance struck by Congress. Perhaps because of this difference, military courts are often use the term military due process to describe rights to which the accused at a court-martial is entitled. The Constitution contains other explicit rights applicable to various stages of criminal prosecution. Criminal proceedings provide both an opportunity to contest guilt and to challenge the government conduct that may have violated the rights of the accused. The system of procedural rules used to conduct a criminal hearing serves as a safeguard against violations of constitutional rights that take place outside the courtroom. The difference in procedural matters between the military justice system and the civilian court system have frequently given rise to debate. The Supreme Court has called military justice a system of justice separate from jurisprudence in civilian courts. Members of the armed forces are subject to rules, orders, proceedings, and consequences different from the rights and obligations of their civilian counterpart. Accordingly, the military justice system is designed to strike a balance between individual liberty and the unique needs for discipline. The Constitution specifically exempts military members accused of a crime from the Fifth Amendment right to grand jury indictment. Let me read that again. The Constitution specifically exempts military members accused of a crime from the Fifth Amendment right to a grand jury indictment. So it's unconstitutional to charge a veteran with an indictment of a grand jury. The Supreme Court has inferred from that absence that there is no right to a civil jury in a court-martial. However, in part because of the different standards provided in court-martial, their jurisdiction is limited to those persons and offenses the military has legitimate interest in regulating. So to be subject to the UCMJ or to a court-martial, right, you have to be a person and the offense the military has legitimate interest in regulating. We'll come to find out the military has jurisdiction, and anything it wants to have jurisdiction, it just has to claim it. As far as being a person subject to it, well, that's what the UCMJ tells us. We'll go take a look at that right now. So, as we can see, the entire Uniform Code of Military Justice is only 35 pages long, Sheriff, right? So I suggest you get a copy, right? Just Google Uniform Code of Military Justice and find a copy. And, spend a little time reading it. You'll be doing your country a fantastic service. If you want to be a constitutional sheriff, you need to understand that it's unconstitutional to have a veteran be tried by a civilian court under an indictment of a grand jury, right? They have to provide us military due process. Who is it? Well, Article 2 is persons subject to this chapter. And, you could read through all these different ones and pick which one you believe applies to you. But, this is the one that applies to me. B, the voluntary enlistment of any person who has the capacity to understand the significance of enlisting in the armed forces shall be valid for purposes of jurisprudence under subsection A and change a status from civilian to member of armed forces shall be effective upon the taking of the oath of enlistment. So once I enlisted, took the oath, I was no longer a civilian. I cannot be tried in a civilian court, nor can any other veteran. You have to take us to the military. Our accuser does. You don't have to do anything. Our accuser has to take us to the military. But if we're not being taken to the military by our accuser, then you do have to do something. which is to apprehend the accuser, because he's denying us military due process. Right? So, veteran, first of all, you need to know which one of these applies to you. And so most everybody, short of, the few World War II vets we have and Korean War vets, right? And then Vietnam vets, right? That this B doesn't necessarily apply directly to you, but what one of these other sections does, which would be like A, because you've never been discharged from the military, right? Your DD-214 they gave you didn't discharge you from the military, just discharged you from active duty. We're still all serving, and these are things I've talked about in my most recent videos already, such as is military justice our relief? And Uncle Sam ain't released me yet, and General Flynn tuned me in, and Don't Ask, Don't Tell Repeal Act of 2010. All these kind of fit together. Right? But at the end of the day, what links them all together is the UCMJ. Okay? And then beyond that, then they have this jurisdiction to try, certain people. Okay? So they have all these, things in the UCMJ, which is its own jurisprudence system outside of the civilian system that applies to anybody who's subject to the UCMJ. So here's another one, Article 14, delivery of offenders to civil authorities. Under such regulations, the Secretary concerned may prescribe a member of the armed forces accused of an offense against a civil authority may be delivered upon request to the civil authority for trial. Which means, Sheriff, you can't put me in the back of your frickin' car and take me to the, to the jail or any other veteran, right? Unless it's been done under Article 14. Right? You have to contact the military and ask them to, the military to deliver the veteran to the civil authority. And then under Article 15, which, most any enlistee would know about, this thing that always hang over your head, you could get in Article 15, which is non-judicial punishment. It actually says in here that you are entitled to a trial by court-martial if you are subject to the UCMJ. So you don't have to go to civilian court. You just demand trial by court-martial. And then in Article 30, it talks about the charges and specifications, right, which shall be signed by a person subject to this chapter under oath before a commissioned officer of the armed forces authorized to administer oaths. It shall state that the signer has personal knowledge or has investigated the matter set forth therein, and that they are true, in fact, to the best of his knowledge and belief. Right? So, a veteran cannot be tried by the indictment of a grand jury. He can only be tried if charges and specifications have been filed, right, before and sworn under oath before a commissioned officer of the armed forces authorized to administer oaths. And so in AR 27-10, which is for military justice, it says in there that, any commander can administer any oath required for military justice. But they have to be in the military, right? So the judge can't do it. The attorney, magistrate can't do it. They have to be commissioned officers of the armed forces to do it. So if whatever paperwork you have doesn't have, the seal of a commissioned officer or the signature of a commissioned officer of the armed forces, it's unconstitutional to administer it or to enforce it on a veteran. And then finally, just real quick, would be Article 139, which talks about redress of injuries to property. Right, so this would be like a civil case where some esquire is trying to foreclose on some veteran's property, or a civil seizure. Right, whenever a complaint is made to a commanding officer that willful damage has been done to the property of any person or that his property has been wrongfully taken by members of the armed forces, he may, under such regulations as the Secretary concerned may prescribe, convene a board to investigate the complaint. Right? That's how it's done. You cannot take a veteran directly to a civilian court and then say we're going to foreclose on your house. Can't do it. If you believe that I owe you money, you need to go and fill out an Article 139 request, right, before a commanding officer for them to convene this board to look into the matter. And you have to get the authority or the authorization under Article 14 for the military to deliver the UCMJ protected individual to a civilian court to be tried. And so, for us veterans, that's really all we need to know. All the rest of the shit is what they need to do, right? They being the military, or they being the civilian authority, or whoever it is. We just need to make sure that this is what they're doing. And if not, well, then it's time to bitch that you've been denied military due process, because this is where it comes from. So with all that in mind, what I wanted to do is, I got to think of something, short, sweet, complete to write up that you could send to, somebody who claims to be a constitutional sheriff or not, doesn't really matter to me, your county sheriff, veteran, right, to put them on notice of your status. And so I'm not saying that this is exactly the way it should be, but it's just something that you could copy and paste. I'm going to put this in the description of the video, and you could copy it and paste it and then change it to fit how you want it to work for you, right? But somehow we should be noticing our county sheriff, right, in a very, friendly manner. Say, notice county resident and U.S. Army veteran Robert Allen Ratluski, my DoD number, is subject to military justice, not civilian courts. Sheriff blank, the Fifth Amendment to the Constitution of the United States makes it unconstitutional to charge a military service member by the indictment of a grand jury. And military justice requires civil authorities formally request the military deliver military members accused of any civilian offense to the civil authority. Article 2 of the Uniform Code of Military Justice, that'd be our UCMJ, identifies voluntary enlistees like myself as subject to military justice, and I am entitled to military due process under the UCMJ. Military due process requires all criminal allegations against a service member to be filed as charges and specifications in accordance with UCMJ Article 30, not by grand jury indictment. Then, for a military commander to convene and complete an Article 32 investigation, and the civil authority requests the military deliver its member accused of an offense to the civil authority in accordance with Article 14, before any probable cause exists for law enforcement to disturb my peace. Article 139 of the UCMJ requires anyone claiming I am withholding or damaged their property must file a complaint with the commanding officer, who will convene a board of inquiry to investigate the complaint. Military due process applies to all veterans, including you or your deputy that may have served in the Armed Forces of the United States. Veterans do not answer to esquires, including ones impersonating as prosecuting attorney or state judicial officer, i.e. civilian justice or judge, unless they have complied with the UCMJ. Esquires, by definition, are crown agents and represent a foreign power. Therefore, Sheriff, you cannot seize by civil forfeiture or foreclose on the property of a veteran, issue or enforce civilian legal process, such as a traffic ticket, without the act being considered treason against the United States for aiding its enemies, unless military due process was followed. Unfortunately, I now find myself unconstitutionally forced to answer as defendant in a civilian court convened in this county under case, whatever your case number is, and I need you to provide relief from this unconstitutional malicious prosecution and protect me from belligerent esquires. Now, maybe you don't even have a case, so you wouldn't put that in. I'm just saying, Let's contact put the sheriff on notice who you are. Say, Sheriff, I'm not your enemy, right? But, I'm not going to a civilian court unless that court has complied with the military due process. And, the one between me and the court is the sheriff. So if you have all these veterans now sitting in jail that were not given military due process, and the sheriff is truly a constitutional sheriff or claims to be one, then he has a constitutional obligation to let them veterans go. And then all them fucking bonds that are written are all going to go into default, and we're going to have esquires and judges and, all sorts of deviants running all over the place looking for protection or someplace to hide because the devil's going to come looking for his pound of flesh when that, when the next payment on that bond comes due. Because the res will no longer be in the freaking warehouse, right? There will be no more warehouse receipt for the res, which is what they're trying to use us for. They're trying to make a person be property and put them in a bonded warehouse, right? But that isn't what we're going to allow them to do. We're going to say, no, I'm under the UCMJ and you have to take me to the post. And if we could just crack that nut and, get everybody to agree with that, this whole charade that we find ourselves in of this fictional system run by esquires acting as, judges in our legal system would go away. Right? By definition, an esquire is a crown agent. And crown agents are, and the crown is a foreign power in the United States. So I don't have to answer to it, Sheriff, and I need you to protect me. So I really don't have much more to add at this time. I'm going to be trying a few things, writing some letters to different sheriffs where I know certain veterans are being held to see if I can get anything done that way. But it'd just be a lot easier if every veteran would, take care of their own business and contact your local sheriff and see if we can get some kind of dialogue started. And if you're a constitutional sheriff and you want to talk about this and add your 2 cents, please contact me. Right? I'm not your enemy. Right? I'm your advocate. I'm going to direct your power to where it needs to be directed to, which are the belligerents, esquire belligerents, who are impersonating as public officers because they haven't taken the proper oath of office. Neither of you, by the way. That's because you listen to an esquire. But this shit has to come to an end. And the way to end it is just release veterans and watch the whole thing collapse. Because, there'll be no more res in the bonded warehouse to back up the bond that's been created. And now someone's going to have to pay for it. Okay, I'm going to leave it there. Have a great day, and I hope I hear from a constitutional sheriff, somebody who wants to do the right thing, or police chief, right, or deputy. Doesn't really matter. Just somebody on the other side of the fucking fence, right, that wants to do the right thing for God and country. We need to talk. Okay, have a great day. See you.